Time to check in with Chris Dimakos. He's our CJAD legal contributor. Chris, I want to start off with a story. We often talk about, employer-employee situations and who has what rights and what should you do. Then came across this question, which was sent in actually by an employer who turns out hired someone to fill in for someone on mat leave, right? A cover for a period of 18 months, and then says or asks the question, the new person's performance far exceeds the person who left for parental leave. What are the rules about keeping the new person? So let's deal with that. What are those rules, and can you even do that?
Right. And, the rules are, in black and white, and they're in legislation. But in practical, what happened in the real world is a lot of gray area. And you gotta make sure that you are sound in your strategy if you want to basically, dance around those rules and make decisions that one might presume to be not in accordance with law. So I'll give you an example. If someone goes on mat leave, they are entitled to job security and job protection. We have these laws to make sure that if someone wants to take the time to have a child, well, then they're not worried about their job. So it's important for us as a society to have these laws and to have this job security that's there. That being said, the law protects your job and says that you are not to be disciplined or demoted or terminated or have your salary reduced, whatever consequence to your job conditions, you're not supposed to have any of that if it's because you decided to take some time off and have a baby. So when you take your mat leave, you are entrusted with a lot of job security. That being said, the question comes up, well, what if it's not about the maternity leave? What if it's just purely a question of performance? An employer says, I want this new person to work more so than the existing employee because they just perform better. Well, my advice to the employer would be you have to tread very carefully because there's a presumption that if this employee who's on mat leave gets fired or terminated, there's a legal presumption that says you did so because they took mat leave. So you got to kind of dig yourself out of that hole from a legal perspective if you're going to have that challenged in court and show to the court this decision was solely based on performance, not based on the fact that the employee took mat leave. It's a very difficult thing to do. And what happens in real life usually is if an employer speaks with their lawyers and says, listen, we want to package this person out, they have a negotiation set. They sit down with the employee and say, hey, listen, here's what's going to happen. We want to help you out of this transition. We want this other employee now because of performance or whatever the case may be. And they come to some sort of financial settlement to have that employee leave, because doing the reverse, which is just terminating them, usually brings on a lawsuit, and the cost associated with that usually exceeds what it would cost just to sit down and negotiate a split.
So the question from this particular employer, at least in this particular case, is, well, what about if the original employee who was on mat leave comes back, they keep her for 6 months or whatever, and then give her notice and she's done. So they've respected her rights. Then she comes back to work and they're going to say, well, we're going to let you go. Is that a way to get around it?
It could be if you can show that they came back, and it all depends on what your reason is going to be. If your reason is performance, well, then you have to have all of the legal ammunition you need to justify performance, which is performance reviews, how they didn't meet expectations, how they had targets that they couldn't meet. They might have made mistakes. So if that's going to be your angle, if it's going to be a performance issue, well, then you need the legal ammo to be able to have it stand up in court if it gets challenged. But again, when you're working with dates that are really close to the mat leave, the closer they are, even if they're outside of that legal presumption delay, the closer they are, the harder it is for the employer to establish, hey, it had nothing to do with that. This is a question of performance, and the question usually comes up, why wasn't this the case before they went on mat leave? How come this employee was fine before they went on mat leave? And they'll say, well, we weren't aware of how bad it was until they got replaced. So it's very factual, but again, I always recommend make sure that your strategy is sound, because it can cost a lot of money.
That's quite the issue, isn't it? Having them come back and then having your employer say to you, we had no idea how bad you were until we found someone who was so much better.
Well,
good luck
not only
with that.
One last thing. It's within the tribunal's right to reintegrate that employee back at her job. So, for example, If they get terminated based on performance, it gets challenged. There's a possibility that that employee gets their job back, which sends a message to all of the employees at that company, hey, ownership doesn't have carte blanche here. If they do something that's not legal, you can have it reversed. So, again, my advice to employers, if you want to go that route, make sure your strategy is sound and that you have the legal ammunition to do what you need to do.
Chris, last one real quick. A couple has a child. This is a story about a couple out in BC. They go to court over the terms of their separation. Boyfriend says, hey, we're living common law where division of assets, not applying. The girlfriend says, wait a sec, we were not a married couple because of the way the boyfriend treated her. So I'm trying to understand, what's the story here?
Yeah, so although we don't have that common law marriage here in Quebec, they were trying to argue the boyfriend was saying, we're common law, so we get to partition our assets based on what would it be like if we were actually married. And the woman was saying, no, we weren't. We weren't in a common law relationship. And what the judge used, which was the main factor in determining that they were not common law, even though they lived together and they had a kid together and they paid bills together, it was the text messages that was sent by the boyfriend to the girlfriend, the way he spoke to her and what he called her and the names and the vile text that he sent. The court said that does not seem like someone who's in a relationship, a common law marriage. That seems like someone who has absolutely not wanting nothing to do with the other person. And it was ruled against the boyfriend's case just because of text messages. The lesson here is, remember, if you're full of emotion and you're getting into an argument, I know it's become now the knee-jerk reaction to pick up the phone and vent and write whatever you feel like writing. But it can end up costing you hundreds, if not thousands of dollars, not only legal fees, but in rulings and judgments. So what you write sticks around, and it can be used against you. So think twice before you go on a rant with your significant other on a text message. It can come back to haunt you.
All right. Great news, or great advice as always. Chris, thanks so much.
Thanks, Aaron.